What are my rights where another company has trademarked a name that I've been using for 8 years?
Yeah.
What are your rights?
It depends. You may have pretty strong unregistered common law rights to the name, which you could potentially convert to a trademark registration at the USPTO. Whether or not you can apply for the trademark and successfully cancel the third-party trademark depends on a number of factors. The primary factor is going to be, one, you're going to have priority of use before the other party. So you have to go to market, begin offering products or services for sale before the other party either filed their trademark application or began their own product and service offerings. So assuming you have prior use of the trademark, so priority of use, at that point, you need to look at and see how long this third-party trademark has registered. If it's been 5 or more years, they might have filed what's called a Section 15, which makes the trademark incontestable for priority of use purposes. So you might be denied based on that third-party registration. So I would recommend talking to a trademark attorney. They'll be able to, more accurately do some research and determine whether or not you have the ability to enforce the trademark, register it, and cancel the third-party trademark.
Got it. So it's not game over just
Nope.
because someone else has registered a name that you've been using.
Yep.
I mean, there may be some work to do. You have to dig in and see how much prospective right you have. Have you lost anything by in a way sitting on your laurels and not filing?
You have. So there's a couple different, different defenses to trademark infringement. There's, estoppel defenses and acquiescence defenses. So, essentially one is that the person's been using the trademark for so long, typically 5 or more years, it would be unfair for the USPTO or a judge basically to say that they have to, throw away the trademark. They've accrued some rights in the trademark just by using the trademark for 5 years without anyone bothering them. Then there's the acquiescence argument where, the client should have or did have active knowledge of the third party infringement, but chose to, sit on their hands for a couple of years. And if that's the case, then you can be, stopped from enforcing the trademark at that point.
Got it. Cool. Thank you, Matt.
Yep.
Very good answer.